know we're usually here on Mondays, but there was real work to be done, right? Real important work to be done yesterday, so we did move our live pod to today. So thanks for joining us. I'm going to hop on real quick so I can read comments for any questions that you all have. But as I'm doing that, I'll go ahead and introduce everyone here. We've got Luke and Bryan Sheely. They're the twins that run the Sheely Law Firm here in Columbia, South Carolina, also located in Charleston, South Carolina. You may have started following us in the Bring the Jury podcast from our Murdaugh coverage a few weeks ago. We had a lot of fun with that. And what's brought you here now, where we cover different popular cases happening all over the nation. Like, for instance, today we'll be talking about the Idaho 4 and specifically Bryan Kohberger. You can always find us on TikTok, Instagram. We're also on Facebook, LinkedIn, YouTube, and Twitter. So feel free to follow us on those. If at any time you feel love in your heart to donate to the Bring the Jury podcast, we would greatly appreciate it. You can find those links on Spotify, Google Pod, all that good stuff, or on our social media platforms, YouTube, Instagram, all the things to do that. So any amount is greatly appreciated. And I think we'll just go ahead and
talk about why Bryan's wearing glasses.
And yeah, Bryan has decided to wear glasses. There you go. So if you ever have a hard time telling Luke or Bryan apart, now it's made a little bit easier with glasses. Is that just to cover up maybe tired eyes?
It's just the allergies, you know.
The allergies.
But you know, if this is helpful for our viewers, then I can keep it going. But it's like the pecan little wormy things are falling from the sky in South Carolina, and it's just savage.
Yeah. Do twins have the same allergies? Do you have that same problem?
Yeah, but I'm a lot tougher. I'm not just a big baby. I just kind of suck it up. Yeah, we can talk about that. We can talk about his lack of toughness.
Sure. I would love to know, just our listeners that are tuning in, comment who you think is the older twin. We're not going to reveal it yet, but that'd be fun. Do you think Bryan is older or Luke is older? And bonus points if you guess correctly.
How certainly looks older.
Anyways, we're going to go ahead and jump right into a different Bryan. We're going to talk about Bryan Kohberger and kind of everything that's been happening with the Idaho 4 case. Bryan, if you'll just kind of start us off giving us a quick recap maybe of where we're at today.
Yeah, Bryan Kohberger is charged with 4 counts in Idaho first-degree murder and 4 counts of burglary. The basic facts are these young college roommates in Moscow, Idaho, were killed. Around 4 to 4:25 in the morning, in November of last year. There were 2 living roommates that are key witnesses in this case. Bryan Kohberger has, denied anything. He apparently was a Washington State criminology student. I think Luke's going to talk, and I can help as well, about a lot of the evidence that we've covered before, but there's cell phone evidence, there's DNA evidence, there's some physical attributes to the killer that have some similar core links to Bryan Kohberger, and then there's some other things going on with him, some latent shoe prints and some other things they found with some search warrants that they executed on both his Washington apartment and his parents' house in Pennsylvania, because he's a Pennsylvania guy. And we're going to play a fun game a little bit later on about what they found in his parents' home that seems very sinister, and we'll see how sinister that is. But Luke, you want to talk about some of the critical evidence in the case the prosecution has?
Well, yeah, probably their biggest evidence is DNA left on a sheath of a knife that's they believe was used in this crime. It's definitely a knife, an edged weapon, and they have a single source DNA, and they claim to have eventually done a trash pull of some objects at his parents' house, and at least as far as preliminary, tried to claim that it was enough of a match, so to speak, that he or another male familiar family member could not be ruled out. And of course, he's a his dad's there. And I think we've told some stories about what that means. They're going to need to get like a real independent, clean sample and do a Schmerber hearing and get it and compare it. But for right now, that was a big lead for them.
Luke, just because not everyone that's watching is a lawyer, what is a Schmerber hearing?
Well, a Schmerber hearing is
This is a legal pod, so we can't just throw terms out there. We got to talk about stuff.
Well, there's frequently cases where the prosecution wants to use DNA evidence to their benefit, and they might be early in an investigation and have something. Let's just say they run some DNA through a national database and get a hit because a client has a terrible, heinous crime in his past, and due to that crime, he was forced to submit his DNA. And so they might say, wow, this is perfect, this solved our case. But they can't use that in evidence in a trial because, for due process and fundamental fairness reasons, you can't have the officer go, yeah, his DNA match because he's a sex offender pervert, and that's why it was in there, and I just matched it right up. You can't do that because it wouldn't give him a fair trial in this unrelated matter. But based on that, they certainly could have a separate hearing and say, Your Honor, we've got probable cause due to the match. She was in the area, and this really is the basis. XYZ reasons. It's just probable cause. It's not an overwhelmingly high threshold. And then you can get a nice, clean buccal swab where they'll rub the interior of the suspect's mouth, and now they will take that sample and compare it against what they found and collected on the scene. And then they can, if that is a match, which it should be, if the DNA case was a match, then they should be able to present that cleanly in a trial without having to talk about, the database match. So that's what they like to do. Sometimes you don't have a hit originally, but you have some reason why you really truly believe it was your client. Maybe he was picked out of a lineup, maybe he's on video. And, the DNA evidence would just be the cherry on the sundae, so you present that to a judge for probable cause, and then you go get it. In this case, they had lots of suspicion, really based on his car and on some other things, like the suspicion of his cell phone not being particularly active at the time.
Which law enforcement finds that to be suspicious, right? If your phone's inactive?
It's very suspicious, but of course, if your phone is pinging at the crime scene, then that's suspicious too.
Bloody shirt? Guilty.
Right.
Clean shirt?
Guilty.
Suspicious. Yeah.
Clean shirt, you covered up, bloody shirt's guilty. So and we can read right in their affidavit that they found. Now, I will admit that, it wasn't like Kohberger's cell phone just pinged constantly at his home, miles away. They reference it being there and then just kind of going dark. And then allegedly to the ride, it's not pinging him there because they would suggest that he turned it off because he's a criminology student and he gets off on crimes, and they want to think that he's smart enough to do that.
He's a PhD student in criminology.
Right.
Yeah, which I think we talked about one time about how you could almost be like the perfect criminal.
Right.
Because he's like studying how to be the perfect criminal.
But then the phone kind of comes to life, maybe not so wisely, somewhere on the car ride home, if you're from law enforcement's perspective. So now, there's lots of reasons for that. They want to say because he thinks he got away with it and he's being a little careless, but you could also have a dead phone that you need to charge and you plug it in and there you go. So, but they do make a big point of saying the absence of evidence is that evidence, which I always find ironic and somewhat disingenuous. But, so they were really excited, and they didn't need a warrant to pull his trash because, again, we talked about it, when you put your trash on the street, it's everybody's.
My trash.
The sticky, icky stems, don't be throwing those away in the trash can.
If they want your DNA from your trash, there's nothing in God's green earth to stop them from doing that. And so they took that to their single source profile, and they claim that it is at least a significant enough match where they believe that it's good for them and can go forward, even though it may not rule out his father. And of course, as a defense lawyer, you fight the battles that are important to fight. You don't sit there and necessarily try to blame dad as the guy that did this crime, but you want to, attack as best you can. So that's a lot of the case. They, on one hand, they paint him as this guy who tried to plan a meticulous crime, but he's also dumb enough to leave a sheath on the scene. So both of those things can't be true. But if I'm the prosecutor, I'm saying, well, he planned it quite well, but then the reality of the moment, he still panicked, he still struggled, or he still was sloppy enough to not execute the perfect crime, even though he may have planned it. So I know there's a footprint that I haven't heard that they've done anything crazy with. I know early on that they referenced it kind of being similar to one of the students that lived there because they had an idea of what her shoe was from a prior noise complaint. So I don't know that the footprint.
We've got some creepy things that are said by two of the witnesses that are left alive. There's someone hearing a voice say, well, there's someone here. And then as a response says, it's okay, I'm going to help you, which presumably is the intruder or Kohberger. And then there's some physical descriptions of a white male with an athletic build and bushy eyebrows, however, wearing a mask. And so, the jury will have to be the judge of whether Kohberger has bushy eyebrows. I think we've all looked at him, and he certainly doesn't lack eyebrows. But whether they're bushy or not, it's hard to say. And then we got this DoorDash right at this 4 a.m. to 4:20 timeline. There is this DoorDash, and so there's a lot of law enforcement information about, a car being seen doing a 3-point turn, and that being credibly linked to Kohberger. And so, it could be a situation where the defense is going to try to rely on a DoorDash driver. If it's like a third-party guilt case and you're trying to assert that someone else did it, well, maybe it's a DoorDash driver. Certainly there are a lot of criminal elements with either people attacking delivery people or delivery people, doing some stuff. It's not beyond the pale, but the DNA from a K-bar knife sheath is certainly going to be a problem for the defense, but they may be able to challenge that DNA in a way that we're not even aware of yet. There is a massive gag order on this case.
Someone just was asking about that. Go ahead.
Yeah, a judge in Idaho who's presiding is saying, listen, no law enforcement, no defense counsel, no lawyers for witnesses are supposed to speak about this case in the state of Idaho. And so unlike some of these other nationally covered cases, it's really kind of tight-lipped. There's a lot of speculation about what the evidence could be. We basically are kind of running off of this initial kind of search warrant unsealed application that gives us a lot of good details, but there is, which I'll talk about here shortly, this prelim, which is scheduled for June, which, prelim, for those of you that maybe are unfamiliar with the term, is a probable cause hearing. And it's really one of the only opportunities that defense counsel gets to cross-examine certainly the lead officer in a case. It's sworn testimony. They got to put their hand up and say, I'm telling the truth. It is testimony that's available to be recorded and used by law enforcement and defense counsel down the road. So if someone, I've said repeatedly on this podcast, no one says the same thing twice. No one says the same thing 3 times. Even if they're trying to be as truthful as possible, there's always ways that people say things differently. There's room for impeachment. Really bad lawyers will go ahead and just waive a prelim and say, I'm too lazy to take the time to prepare to cross-examine an officer. And we never do that. We always find prelims as a really good opportunity to either get a case dismissed or potentially impeach a witness where they can't really recover at trial because they've been found out, so to speak. And we could talk about what kind of the real discussion points. Hannah, can you close that blind over there? I'd love to talk more, but I can't see. I need to like put something down the I don't know if
I mean, the bottom one will help. I don't mean.
Oh my goodness.
The top it is what it is.
I wonder if we could bring this table back a little bit. I'm just.
Yeah, you can scoot back a little.
Can we all bring it back a little bit? Is there a way to do it as a team? Ready? 1, 2, 3.
Oh, that's the cord of my
Teamwork.
Wow.
Well, if I can slide it back a little bit, I'm not exactly up on.
Perfect.
So much better. But, there's a lot of commotion about this prelim because, in Idaho, prelims are a little bit more extensive apparently. So, normally a prelim is just the lead investigator establishing probable cause before a judge. And it's kind of like not a rubber stamp mechanism, but is a procedural hurdle that law enforcement has to overcome before they can ever take the case before the grand jury or go to trial. And so here, because probably of the significance of the case, I mean, it certainly could be a death penalty case. Luke's done a number of death penalty trials. We talked about this case has all the potential to be death eligible. It's probably being treated like a death penalty case in terms of investigation, mitigation, staffing, and resources by Kohberger's defense lawyer. But so they're really kind of gearing up for this prelim, but the real significant kind of discussion point is that one of the living roommates, Bethany Funke, Funke,
Funky.
So she no longer lives in Idaho. She now is back in Nevada, however you pronounce that, where she's from. And the defense has gotten a subpoena to compel her attendance to this prelim so that she can testify. And an Idaho judge signed off on the subpoena. And basically, she had to hire lawyers, one of which is a former prosecutor in Nevada. And they're challenging it. They're saying, we don't feel like that they've successfully compelled us with an out-of-state subpoena. I want Luke to touch upon how difficult it is to get an out-of-state subpoena. But they got her served, and she was basically being made to come to Idaho. And defense counsel are quoted as saying that Bethany has exculpatory information in this case, that she's a material witness and that only she can testify to this. So they're basically putting out there in this.
Do we know what type of evidence?
We do not. There's this gag order in place, so we don't really have a clue other than she was interviewed by law enforcement. Her cell phone has been downloaded. It's been forensically downloaded, so there's going to be a lot of information about her movements and various things, but there's enough information right now that Mr. Kohberger's lawyers are compelling her attendance. So Luke, what can you do with exculpatory information at a prelim? And I'm going to talk a little bit about the result of the subpoena, but what generally can a good defense lawyer like you do with exculpatory information with a lead investigator on a big murder case at a prelim?
Well, a case like this is very unlikely to get dismissed, but anything exculpatory.
Wait. What? That judge is sworn an oath to uphold their duty, and everything's fair and impartial and unbiased. And what do you mean?
The eyes of the world upon them. No, I mean, as you know, we've gotten murder cases dismissed at prelims.
Yeah, we have.
But it was not the Idaho 4, and it may not be appropriate. But so the state just has to prove probable cause through their witnesses, and typically that's the lead investigator. But if there's something exculpatory, it would tend to show your client's innocence, tend to show something inconsistent with guilt, in this case, inconsistent with murder.
And that's what they're saying.
And that's what they're claiming. I don't know how they know that, but there's something as part of their investigation. Maybe she talked to their investigator before she...
Maybe she said something inconsistent to law enforcement that
did.
Helps Kohberger.
Maybe she's given a completely different description of the suspect, and he was 5'5", light brown skin and
Looks like a DoorDash driver.
Yeah,
That
no
was-
eyebrows.
or tattoos for eyebrows.
Yeah.
So like I once had a client who had tattoos for eyebrows. So
Wearing a DoorDash uniform.
Where is that guy?
where did he go? He was real scary. But so you want that at any hearing like that to confront. You want to commit that witness to whatever is exculpatory, and then you want to confront the investigator with why he didn't know that, or why he's hiding it, why it didn't fit into his theory of the case, why it didn't influence his theory of prosecution, why did you get a warrant if you had this exculpatory information? So
We have a good question on this subject. What is Brady evidence? The question is, what is a Brady law? But I think it's referring to the Brady line of cases and the duty of a prosecutor to provide that material. Talk about that a little bit for the audience on this law pod.
Yeah.
well, it's not just the evidence that a prosecutor has to turn over that's incriminating, that's so you can know what you're facing, but it truly is something that's material to your case, that could be exculpatory, it could be impeachment, that it violates the Brady case should they sit on it. Prosecutors we are duty bound to be zealous advocates for our client. If a client brings me a gun, I don't have to turn it over. Unless I know he's about to commit a crime or that he had just freshly committed a crime and told me about it. But prosecutors are technically deemed to be ministers of justice. They're not, it feels like they're advocates for the state, but that's not really their job. They're meant to do justice, and typically that's for the state of wherever they're prosecuting. But if they find something that's inconsistent with a defendant's guilt who they're prosecuting, something that they know could help, it's not their job to hold on to it so they can win. They have to turn it over. And so there's a lot of Supreme Court cases, Brady being one of them, Cosby, Whitley in South Carolina, good old B. Osment, Giglia in the federal system that requires these things to be turned over. So it's a pretty bold thing for the defense to say that they believe that she possesses that. So it piques everybody's interest. It's just very hard to get a witness who's uncooperative out of state.
So here's what they did. So they moved to quash the subpoena. Bethany Funk's lawyers did on her behalf. And there are unique challenges because most states only have statewide subpoena power. And so here, Bethany's getting served with an out-of-state subpoena from Idaho, which, they're challenging it. But the compromise that has occurred, and this is the most recent development on this, is that instead of her coming to testify at the prelim as a live witness, she is going to meet with Bryan Kohberger's defense counsel and presumably his investigator and give a statement to them. So she's willing to cooperate and be interviewed by Kohberger's legal team for the defense before the preliminary hearing. The preliminary hearing is in June 26th. So we're here at May 2nd. So this is another the sworn testimony is great. A sworn statement, because what you can then do, if there is exculpatory information in that, you can then take that before the prelim and give it to law enforcement. Make sure the lead investigator has it, because the truth never just ends with a warrant. No law enforcement officer that's doing a major homicide investigation is ever going to say that their case ends with a murder warrant. They're going to always say, as we would cross-examine them, you're always looking for the truth, and the truth never just ends with a warrant. You want to know more information. You want to get to the bottom of it. You want to help your case. And if you find something that is exculpatory, well, you want that information too. And they're kind of jammed up. If they go, no, I only want what helps my prosecution, even if it's not the truth, they're never going to say that. So when you get new information, like an exculpatory statement from Bethany Funk, and you give it to law enforcement, then at a prelim, you can effectively cross-examine and impeach an investigator with the exculpatory information. And this is new information that you didn't have when you swore out the warrant. And you always want more information because you want the truth and you want justice and you want fair and right, and you're looking for more. You're never closing the door to information, are you, investigator? And they'll say no. And so then they're confronted with whatever Bethany is going to say, And then a good lawyer like my brother here, or maybe even myself, can make a motion that it has, cut the legs at a probable cause and make a motion to dismiss. Not that any judge on a death penalty eligible case with this much scrutiny is going to dismiss it, but what the real result of this will be a sworn investigator having to deal with new information of exculpatory nature potentially on the record that then Kohberger's defense team can use effectively down the road at trial, right, Luke?
Right, and if the compromise being struck, although you might not have live testimony at a preliminary hearing by this witness, it's a real feather in the cap of the defense because, I don't know, if I'm them and she's coming from out of state, I'm going to audio record it. I might get I'll have a court reporter there. You really want to make sure it's truthful and accurate. And there's no doubt that what she's saying is what she's saying. We can only assume that she's highly cooperative with the prosecution, given that her roommates were killed. So that's the thing. And she may ultimately be planning to come to trial just because she wants to. And if a witness wants to come from out of state, that's great. And the prosecutor can say, look, you're important to our case. This is a terrible tragedy, and honor your friends, and we'll pay for your flight. And that's easy. But she may not want to come to help the defense in any way. And that's a natural feeling for her because the state says that the guy they're representing killed your friends. And she's like, well, I don't want to help you.
It's very scary.
So that's where she starts resisting. But if you don't, the one thing I was kind of thinking, there's certain rules that allow you, if you have a witness who fights the subpoena and they win, they're unavailable. So there's certain rules about getting testimony into a case when someone is properly unavailable, but you can't really get their testimony in unless they were previously cross-examined on the matter. So that's what you miss by not getting her testifying live and examined under oath, is that you miss that. You might have a statement or even a video statement from her, but if for some reason she ran for the hills and didn't even cooperate with the state, she hasn't been cross-examined on the matter under oath, so you couldn't just enter her testimony into evidence, which you very well may need to, because she's not being cross-examined. So, that's one little wrinkle. We once had a weird case where it was a murder case, and it was an out-of-state investigator that got a confession from our client in California, and we had a huge pretrial hearing, and so she did come willingly at that point, and for a couple days, and testified under oath about these matters. It wasn't the full trial, but then we had one of our attorneys die, and an expert witness died. It was like a haunted case. And so there's a big gap between that case, the pretrial and the trial. And then for the trial, she said, screw it. Even though I'm a cop and I'm an investigator and I'm integral to this case, guess what, state of South Carolina? I'm not flying back out there. And she fought South Carolina's own subpoena and won. And had a hearing and retained counsel in California. And that judge said, screw the East Coast. I'm not going to make you
West
come.
Coast live.
Right.
East Coast, West Coast.
We're Tupac out here, and so she didn't come. So bizarrely she won, but we had this big battle about whether they could get into parts of her testimony. We didn't want it because obviously if she'd be kept out, that'd be great. But we lost that battle because due to our extensive pretrial, the judge viewed that she had been properly cross-examined on these issues, even though it wasn't the same type of vigorous cross we would have given her had she testified live, but it was enough where they could enter in her testimony, and so we were pretty peeved about that. But that was a weird situation.
Right, and just wrapping up with Bethany, so the state is not requesting her presence for the prelim, and they wouldn't because they want to keep the powder dry, so to speak, on her information before any meaningful trial. I mean, the state would never want to call one of their eyewitnesses in advance. They would want to prep them up. They'd want to do their own in-house prep and kind of not be exposed. But it sounds like she's, due to the subpoena issue, has kind of relinquished that cover and is going to be exposed to the extent that she's going to give a statement. So it's very interesting. The other living witness who actually gives the physical description of a athletic white male in a mask with bushy eyebrows, there's no mention of her in this prelim. So, which makes me believe that the defense is not trying to use her in any way, and unless she's in state and it's not a big thing. But like, the state's not really trying to call these witnesses. So the defense has got all the legwork to do. And again, in Idaho, unlike South Carolina, you get to present evidence. It's a little bit unique. But again, this case is important. It's high profile. And so they are going to allow a lengthy kind of evidentiary style prelim where you get to call witnesses, very much akin to like a grand jury investigation. It sounds like we're in South Carolina, no matter how big the case is, you don't get a real big evidentiary party. You get, if you get anything at all, you get one investigator and that's it. But it sounds like they're going to at least be able to interview Bethany, and that'll be a lot of interesting coverage. We definitely need to come back to the Idaho 4 case after that prelim week, because there's going to be a bunch of information that should shed some light on this.
So let's dive in. And I know we've got a little game to play a little bit, so I'm going to tee that up really quick. So Bryan Kohberger, as like Revlon or L'Oreal would say, he's kind of got the look, right? We've all seen it.
Maybe he's me.
Yeah, maybe he's born with it, or maybe he's a serial killer. I don't know. But he's got the look, right? And what also hasn't maybe helped him, at least just in the media, is what police have found after kind of raiding his home, and even I think his father's home, perhaps. But we have a fun game that Brian's going to play with Luke to go over some of the things that they found in Brian's possession. Not this Bryan, Kohberger's possession. Yeah, to make it clear. And you guys can all play along as well. So Brian is going to ask Luke if he owns said item in his home.
So Kohberger is he lived in Pennsylvania, and so they did 2 search warrants based on all their probable cause information. One on his apartment in Washington State, and then one on his family home because he was there frequently. He was there recently for winter break, and so they got a search warrant. So anytime they do a search warrant, they typically find things of interest, and then they're listed on what's called a search warrant return. So, Luke, they found a number of interesting items, which they, attribute to, the state will attribute to his guilt and, how these could have been used in a crime. But I just want to ask you a couple of questions, because you're kind of what are you? You're kind of a prepper, mountain man. You're like a survival.
Are you a doomsday prepper?
He's a doomsday kind of guy.
I like to prepare for all situations, and when the shit hits the fan,
Hey, TikTok.
All right,
TikTok
there we go.
Yeah.
He's gained like 500 new followers.
Sorry, I've been teaching trial advocacy all day, and I've been cursing my butt off because it's important to make those impact.
Teaching the youngins. All right, so here's what they found at Kohberger's parents' house, which is attributed to Kohberger. Semi-automatic caliber. It's a .40 caliber, but a semi-automatic firearm.
You got him.
You got one of those?
Yep.
Gun magazines. Do you have any gun magazines?
Magazines like that I can read about the next gun I want to buy, or a magazine.
Because both.
Because I got both.
Well, you're covered. But these are referring to gun magazines.
Oh yes.
They found a knife.
Got them. Big ones.
Didn't say what kind of knife, but a knife.
Mm-hmm.
You got some knives at your house?
Lots of those. Cooking, kitchen, cleaning, killing.
Do you have a pocket knife? Because they found one of those at Kohberger's house.
Sure.
So.
All right.
A black face mask.
Yeah, I have that for skiing. I've got masks for hunting when the mosquitoes bite. I have a full pull down, eye holes.
Or when the zombies invade.
What about any black gloves? Do you have any of those? Sure do. All right, so right now you're like 6 for 6 on the Kohberger stuff. Now the final one, number 7. Do you have any electronic devices? Because they found those at Kohberger's home as well.
I think you will find some electronic devices in my house.
So, in all fun and jesting. I mean, sometimes we get dramatic coverage of search warrant affidavits because it's like, oh, we got all this stuff, and a lot of people have this stuff. Luke, you are a perfect match for the Kohberger parents' home in terms of what was found and attributed
And
to.
my eyebrows are quite bushy right now.
Oh man,
Yeah, see Wall tomorrow, but
And this is not to make jest of
No,
the
no.
seriousness that has happened in Idaho with those students. It's obviously a tragedy, and we are all wanting justice for those students. But just to point out how this information could be used from a defense perspective.
I have zip ties, I have duct tape, I have trash bags, I've got ropes. So like, you know, lots of folks have all kinds of things, but they tend to sound sinister when they're on search warrant returns. Yeah, you know, the objectively most sinister thing I think we ever had, we had a murder case and the guy was like basically moving. And so he had tons of guns. He had the murder weapon, but every other gun he ever owned, like a safe full of cash. But what he had that had nothing to do with the case, but that the prosecution could not let go, was a garrote.
What is a garrote?
Now, I do not have a garrote at my house.
Any of our audience know what a garrote is?
Or does any of our audience have a garrote at their home?
But it is a kind of a French, I believe, weapon. It's basically just a steel wire with like handles on the end, so you could put around someone's neck and choke them, or perhaps decapitate them if you pulled hard enough. And so the prosecutor in our case really wanted to talk about that a lot, and we had to shut that down because it had nothing to do with why our guy killed somebody with a handgun.
Now, in that case, the murder weapon wasn't evidence. In this case, the murder weapon is not located.
Right. They don't have it, right?
They do not have it. They have information about what they believe it to be, but they don't have it. It's nowhere to be found on any search warrants.
Mm-hmm.
They do, by the way, execute a search warrant of his apartment in Washington, and they find things like, you know, dark red stains and spottings on pillows, and some other kind of reddish brown stains, which, you know, could be blood, could be something else, but
Sorry, tangent, but someone just had a great point that that's like a tool that's used for cutting clay. Like if you're like spinning clay.
Yeah, so there you go.
Thank you, Angela.
Could just be artsy.
Angel. Yeah, could be a man of the arts.
um,
Sorry, go ahead.
I'm not sure our client was very artsy.
Well,
We do have another question though. Well, this has actually been asked twice now. Do we think that this will go to grand jury before the preliminary hearing?
it's so weird because in South Carolina, which is not the bastion of justice and opportunity necessarily, and we also seem to have the craziest cases, but this is a wild one. But in a high-profile case like that, where a prosecutor doesn't want to give the defense an opportunity to even touch their witnesses, you would not be surprised to find that the case has already been very quickly before the grand jury, because you don't have a right to a preliminary hearing. So if it's indicted, you don't get that. So things might be different in Idaho. There might be some time frames involved. It seems very much understood that there's a prelim that's going to happen. It's going to take a decent amount of time, and it's just a battle over a witness. But in South Carolina, you know, if we had a big case and it was a death penalty case and sensational, and the defense lawyers were pulling witnesses from out of state or doing things generally which the prosecution didn't like, they would just go ahead and indict it. And there's literally nothing that we could do about it. If they had an available grand jury, I guarantee you it would be a priority. So I've had just those cases where I really wanted a prelim on a particular murder case, and sorry, I just got indicted last week. Go home, Luke. And
Go home, Luke.
right.
Can that be a spin-off podcast?
Yeah,
for
Go
us?
Home Luke, that could be a
Go home, Luke.
But just on that note, I think there's too much attention on this case regarding the prelim for the DA to even try that move. I think they're going to have to kind of take their lumps on it and go through the motions on it. I just think there's just too much attention and judicial effort and preparation on both sides. I think they would. I mean, some of these cases are. I mean, certainly whether you bring a death case or not, that's a political process. It's very much, who's in charge of the prosecution, how they feel about the death penalty, is it eligible, do they have the lawyers on staff that could even prosecute it? Those kind of considerations. So I think with this kind of case where it's got a gag order and we've got so much coverage on it and speculation, I think it'd be a hard political move for then the DA to just kind of put the brakes on that and just send it up to the grand jury.
Well, I think that may move us into kind of the last little bit with this, where we want to talk about the links to other, unsolved murder in Idaho and Pennsylvania.
Kohberger is from Pennsylvania, and anytime there's a no motive crime that has maybe unique characteristics, like a knife being used. Knives aren't like the most unique, but it is a personal killing. It takes either someone, in our experience, usually defending themselves close quarters with a knife, or if it's a no motive killing, it's a very sinister, premeditated type thing. So like on a no motive killing where there's no relationship, yet you do the killing in such a personal way, that is like that, alarm bells are going off for criminologists and FBI types about who this person is. And so similarly in this case, with these 4 strangers that are killed by allegedly another stranger in a personal way, but yet with no personal relationship, they start looking at, well, what kind of profiles does this match? Who are young people that are maybe roommates that have been killed in Pennsylvania, maybe with a knife wound, with no motive, no relationship. And so this guy's from Pennsylvania. And so all the local county DNAs are going through their cold case files, and Kohberger's not old. He's in his mid-20s. But you got to start somewhere. And so everyone's kind of taking the dust off the unsolved cases. And there are kind of announcements from Pennsylvania that they're looking hard at Kohberger.
We've got a lot of questions coming in.
Yeah.
So just some last minute questions. Again, if you guys have any other questions about this case or other cases, feel free to drop them in here, and we'll kind of wrap up with just taking listener questions. Starting first with, did they question every other white Elantra owner? Like, why was it automatically Bryan Kohberger? We haven't really heard of anyone else. I guess maybe now this DoorDasher is a little suspect, but
they had such a wide array of Elantras to look at. It's reading the affidavit. They did send the video to the FBI guy who first gave like a year span of white Elantras, then he kind of changed it. But then I think they wanted to look at the school, and they ended up just running across what would ultimately be his, and they just kind of zeroed in on him. So that I think we talked about this before, like why if I'm the defense lawyer, I'm wanting to know from them every Elantra they looked at. And then how did they get out of the Elantra circle of suspicion? Honestly, it could be something as simple as a cop going, he's watched too many Dexters or something, and he's just like, oh man, who's this guy? What does he teach? What is he a student of? Oh man, criminology. Look at those eyebrows, Bo. They all bushy. They bushy eyebrows. Hey, Bo, isn't he the guy that wrote a letter to the other police department trying real hard to help them and solve a crime or improve
Yeah, if y'all didn't hear about that, he wrote a letter to try to
improve electronic criminal detection.
Mm-hmm.
Oh, hey Bo, don't we have something weird in his case? We're not getting cell phones, and let's look at his cell phone. Oh, Bo.
So you guys, we do. Luke's right though. The defense lawyers should get every white Elantra within that year and make that they're canvassing that. They're going into the databases for the DMV and interviewing people. And so all of that, like Luke says, how did you get out of the circle of suspicion? Because it's going to be proper fodder for the defense team to be like, well, that person has an aggravated assault on the record, and you interviewed them, and you just let them go, and you charge him my guy because he got bushy eyebrows? Okay.
And it could have literally been something like, all right, let's pull the DMV photo of every person in let's just say 100-mile radius registered to a white Elantra, and let's let lead investigator look at their picture. Is this bushy? Kind of bushy, little bushy. No, maybe. And so it could be very subjective. And they start looking like, oh man, he's like Dexter. So maybe they get, and then they, of course, if they do a trash pull and they get what they believe is a DNA confirmation, they've got blinders on now. They're done investigating other things. They're only investigating this.
I can invite our listeners and viewers to go to Bring the Jury episode 11, where we do talk about a lot of these kind of preliminary details, including the vehicles, the trash pull, a lot of the other details that we're not covering today. Go to Bring the Jury. How do they find that, Hannah? They want to...
Oh, wow. Well, there's lots of different outlets that you can find Bring the Jury on, but you can find it on pretty much any streaming platform that you can listen to. We're on YouTube, Twitter, Spotify, Amazon, all the good stuff.
You can just tap on episode 11 and we're talking all about it.
Y'all have some great questions coming in, so we'll kind of try to move through these quickly. What would change, I mean, maybe in your opinion, if they decide to lift the gag order?
Wow.
It would just be a nightmare of trying to influence the jury and make a statement. I mean, honestly, a gag order is good in a case like this. It's not good for the public who's dying for information, but I really hate to see attorneys for either side just getting out there, spouting off at the mouth because they think they need to respond or they want to try to shape a narrative. It makes it harder for jury selection because at the end of the day, you're trying to get a jury that's fair and impartial and hasn't been improperly influenced. I mean, ideally you want someone that really hasn't heard about it. So it's hard to do if people are constantly having sound bites in the news. So it would just be a infiltration of sound bites from attorneys, probably.
Right.
People are talking about, the phone pings. Some people have been saying that they believe those to be weak. The timeline doesn't really make sense. This all seems very rushed. Do we want to touch on the timeline and the phone pings and what that could mean?
Well, I looked at the timeline originally. He's got 16 minutes per the state's timeline to kill four people.
Wasn't that also what Murdo had?
That was basically the car ride.
Okay, that was car ride. I'm getting mixed up.
It's a pretty short timeline to forcefully confront folks fearing for their lives, fighting back potentially, dogs barking, chaos, maybe not knowing exactly where you're going. So it's pretty quick. And the phone ping evidence, it is just that. They will go in there and say that he turned off his phone, so it would not ping there. It would have been better for him had it just been quietly pinging at his house the entire time, but they would go, well, he's smart enough to leave it. Yes.
Or he didn't do it.
But the fact that it kind of reawakens, not anywhere near the scene, but kind of what they would say maps the drive like halfway back, is them saying, aha. But, it lends itself to so many other theories. He could get up there and testify that my phone was dead and I didn't realize it. And I went to a bar and I started charging it because I was supposed to hear from my friend and never did and realized, he could say any number of things. It doesn't put him there. And so I always get a little, I don't like disingenuous stuff with the law. So rather than say it is evidence of the cover-up, just say you don't know. It could be either one.
And how they cross-examine the investigators at the prelim concerning what they didn't do is going to probably lend some light on exactly what Kohberger's defense is, whether it's alibi, which, it's got to be alibi defense. He's got to be establishing he wasn't there. He had no relationship. There's no other way to really spin it. He's got to be explaining his whereabouts, so it'll be very interesting, and we'll have to do another one of these at the end of June.
What piece of evidence do you believe the defense is going to focus on the most to show it wasn't him? And this may be something that we aren't aware of yet, that nugget that maybe they're saving, but
it's got to be the sheath of for the K-bar knife. I mean, it's going to be
with the DNA on it.
With the DNA on it, they're going to have to. And apparently, there's been some additional testing in a lab in Texas on this single source DNA. I mean, it doesn't seem to be a massive amount of DNA evidence, but it is one of these DNA hits that is going to have to, like Luke said, they're going to have to take a Schmerber. They're going to have to get a clean sample, so to speak, to use in court against him. They're going to have to attack that DNA. Because right now, I mean, white, masked, athletic male with bushy eyebrows, you got no bloody knife, you just got a DNA profile coming off a button of this thing, and they got his trash pull. They get to his house based on the car and the creepiness of the criminology background. I mean, they're moving fast to try to solve a quadruple murder. And sometimes when people move fast, they can make mistakes. So the DNA is the biggest piece of evidence that will be attacked.
But if they take blood samples from the scene and compare against any red spots or anything at his house from transfer, he is toast.
Oh yeah, wait for that. I mean, that's to be determined.
He would be completely toast because there's really no plausible way to explain that. But we haven't heard about that. If I'm the prosecutor, if I'm a cop and lead investigator, I'm wanting to get the answers to that very quickly. And we don't have that.
And information like that is going to really lock down a prosecution. Will be presumably a decision-making point about whether they serve death notice on Mr. Kohberger, you don't want to lose a case, much less than all the death penalty stakes. I mean, you don't want to kind of go all in and not have enough to even get a guilty on that side of the guilt-innocent stage of a death case,
right? Much
less the penalty stage.
This always seems like a really popular question whenever we discuss really any case, and maybe you guys don't always love to answer it, but in your opinion, kind of at this time, do you believe that Bryan Kohberger is responsible for the killings of the other four? Sigh.
It's so difficult, right? Because all we do all day long is focus on the presumption of innocence and building cases for our clients. So it's really hard to take the lawyer hat off. I mean, we live that lawyer life.
Right. Hashtag lawyer life.
But if we take the lawyer hat off and if the DNA truly is strong, I mean, there's no plausible reason why his DNA should be on a sheath in 4 college kids' house. But now if the DNA is hokey, and we've had plenty of cases where stuff gets hokey and you run with it
due to overreach.
But, because there's a massive amount of just public desire and law enforcement desire to find who did this. And I seem to recall that it was not an immediate thing. It took a while. And so the more that builds, credit to them for not just finding the first Elantra and arresting the guy in it, but
no, this is a great probable cause affidavit.
Yeah,
this 30-page affidavit is full of facts and details that are good. It's sufficient probable cause.
And wasn't there a roommate that fought back, right? I feel like we talked about that a lot in the beginning. And was there ever DNA taken from her fingernails or anything like that?
I'm sure they all were tested.
Some of the victims did fight back. So, all that, there's a gag order in place. Things that normally could have been leaked or commented about are just under seal right now. But I'm sure, and we talked about this on episode 11, check it out, guys, but there's going to be biological material under these victims' fingernails because as much as it's a no-motive case, it was a personal killing, and people, when they're being attacked, fight back.
And the killer wanted it that way.
He did.
That was part of, I mean, this is not, I mean, sometimes a couple will get drunk, and we've had cases where they just get in a fight in the kitchen and grab a knife because it's there. It doesn't seem to be that whoever did this wanted that personal conflict. Knives aren't loud, like a gun, so maybe it's part of a desire to conceal, but you know that you're going to engage in a very personal fight with a human being who does not want to die and should fight or flight. Emotions, adrenaline kicks in. So if there isn't DNA under victim's fingernails matching this guy, that would be a great fact for the defense. Now, if there is, and it's rock solid, alleles match, comparisons match, the reliability is good, again, he's toast. So it's very curious. Those are very interesting facts and scientific evidence. Science doesn't lie. I always like to talk about things that are unbiased. And as long as it's a strong match, then that's very good for the state. If it's weak, or they want to say things like the lack of evidence is the evidence, then it's good for the defense.
Get that weak stuff out.
Yeah.
I think that's a great place to stop. You all had a lot of great questions, though, and kind of more of them are rolling in. So any more questions, feel free to, you can comment on some of our past videos where we have covered the Idaho 4 and Bryan Kohberger, or you can also send us DMs. We're on Instagram, TikTok, all the social media platforms. But yeah, we really appreciate you all logging on tonight, and we'll definitely be back, if not before, we'll definitely be back in June to discuss more about this.
What's the result of the old man poll?
Oh, yeah.
The old man poll? Someone did say that they thought Luke was older.
Oh, yeah.
So what's the truth?
I'm 8
Or you'll have to come back for next episode to figure it out. No, what do you think?
8 minutes older here.
Yeah.
This
8
guy,
minutes.
this guy right here.
I just live harder.
Yeah, you do.
All right, well, thank you guys so much again. One more time all the way through where you can find us. We're on Instagram, TikTok, Facebook, LinkedIn, Twitter, and YouTube. A lot of these clips I will pull, maybe some of our favorite little moments from tonight's episode and post on some of those platforms. If you want to listen to the full episode, maybe you weren't able to tune in for the full thing, you can always find that either posted the video version like this on YouTube. If you just want to listen, it will be posted on Spotify, Amazon, most of all of the streaming platforms where you can find just audio. And also, again, if you have love in your heart and would like to send us a donation, you can do that on the Buy Us a Coffee app. I've linked that donation link on all of our socials and Spotify and where you can find our podcast. Once again, this was Bring the Jury with Luke and Bryan Sheely. My name's Hannah, and we will see you all next week. If you have any recommendations for cases that you would like to talk more about, people were very interested in this case, so we may be back next week talking more about this. But if you have others that you're interested in, please